I apologize for the technical difficulties many of you faced earlier. The volume of participation unfortunately overwhelmed the webinar platform. I'm sure many of you have experienced similar challenges operating in a remote environment. We still want to give you guys this great content, so we're going to proceed and send you out this recording. My name is Justin Dosh. I'm an attorney and director at Vigilant. I've got experience serving as CCO and consultant to investment advisors, mutual funds, and broker-dealers. I'll be moderating the panel discussion today. Vigilant is a full-service investment management solutions firm focused on assisting clients in their regulatory compliance needs. We're thrilled to have some amazing industry connections and have them here today to present with us on this webinar. Today, you'll hear from 3 industry-leading experts whom will each provide a unique perspective on the new SEC marketing rule, from the policy to implementation. Let me introduce first Emily Rowland. Emily is a senior counsel in the Investment Advisor Regulation Office within the Division of Investment Management at the SEC. Emily played a key role in developing the staff's recommendation to the Commission to adopt the new marketing rule and has also worked on other investment advisor rulemakings at the SEC. Prior to joining the SEC, Emily was an attorney in private practice. She is a graduate of Dartmouth College and the University of Pennsylvania Law School. Next, I would like to introduce Mike McGrath. Mike is an asset management and investment funds partner at K&L Gates based in the Boston office. His practice focuses on counseling global asset managers across a broad spectrum of asset classes in the formation and operation of investment funds, regulatory compliance, and securities and commodities law. Michael also maintains an active practice assisting investment advisors, broker-dealers, and commodity trading advisors with respect to regulatory compliance and examinations. He regularly advises investment managers and broker-dealers on marketing and advertising issues, including the Global Investment Performance Standards, or GIPS. He is a CFA charter holder and a member of the CFA Institute's U.S. Investment Performance Committee. Rounding off the panel, we have John Malone, who is a managing director and chief compliance officer at Amundi Distributor U.S., Amundi Asset Management U.S., and the Pioneer family of mutual funds. John has over 28 years of experience in the financial industry and a number of industry certifications. Previously, John worked at FINRA in the Advertising Regulation Department. John has been a speaker at a number of industry compliance conferences, including FINRA's Advertising Regulation Conference, the Institute for International Research's Compliance for Variable Products Conference, and the Actians Unleash Social Media Conference. Now to the format for today's webinar. The webinar will be split up into segments and be in a panel discussion format. What you will not hear is 3 people reading off PowerPoint slides. We will have additional materials, educational white papers, and presentations available for download and distribution. Thanks to our friends at Red Oak, Spalding, and K&L Gates for providing some of these materials. The final segment will be Q&A format, and we do have some questions already prepared that we'll be able to submit and have our speakers address. Without further ado, let's get into the first section of the webinar. Emily will introduce the key changes and background of the rule.
Thank you so much, Justin, and thanks for inviting me to join the conversation today with my colleagues. Before I begin, I want to say my standard SEC disclaimer, which is that my comments reflect solely my personal views and do not necessarily reflect the views of the Securities and Exchange Commission, the individual members of the Commission, or other staff members. So as Justin mentioned, I'll begin by giving an overview of the new SEC marketing rule, including what were the overall goals and objectives, and what are the major substantive changes. And then I'll turn it over to Mike to start us on a deeper conversation of central aspects of the rule. So as everybody listening to this webinar most likely knows, the Commission adopted a new marketing rule last December that has already gone into effect in May. And the rule has a compliance transition period that will end on the compliance date, which is November 2022. The new rule replaces in one rule both of the investment advisor advertising rule and the investment advisor cash solicitation rule. Just as brief background, as you all likely know, the advertising rule had governed investment advisor advertisements made through such means as written communications, radio, and television. And the cash solicitation rule had governed advisor solicitations of advisory clients through in-house and third-party solicitors when advisors compensated those people with cash compensation. So these are 2 rules that were adopted a long time ago and had not been substantively amended since adoption. So the Commission's goal in adopting a new marketing rule was to modernize these 2 rules by addressing modern marketing practices and modern modes of communications, and also the changing expectations of investors. It was also the goal to make the new rule evergreen so that it could apply to future changes in modes of communication. So the hope being that advisors can use the new rule to reach a broader audience with some more regulatory certainty. One change in the structure of the rules, as I noted, is the combination of the two types of marketing activity into one marketing rule. This was done in part to avoid confusion over one rule versus the other rule applies, given the similar marketing context of both of them. So the commission combined the concepts of testimonials and endorsements with other referral and solicitation activity that had traditionally been subject to the cash solicitation rule. Some other high-level changes include replacing the advertising per se prohibitions with more principles-based general anti-fraud prohibitions that apply to all advertisements. So we'll get into those in more specifics in a bit. But just a couple of high-level points here. The rule now permits testimonials subject to both the general prohibitions and additional tailored conditions. And the rule also permits references to past specific recommendations, what's now called specific investment advice, subject to the applicable general prohibitions. And then the rule specifically addresses performance advertising. So a lot of these topics had previously been addressed in staff individual no action letters. And it was the commission's goal to adopt a comprehensive rule addressing these activities. So the staff intends to rescind the relevant no action letters as of the compliance date in November 2022. And in doing so, the commission incorporated or replaced previous staff no action letter positions into the rule and into the rules adopting release. So I want to say one final point before I turn this over to Mike, which is that I urge compliance professionals and others not just to read the text of the rule, but to take advantage of the release and the 200 plus pages of commission guidance that's packed into this release. It's really meant to give participants, to give the investment advisory industry some framework for how to apply the new rule. And I think it could be very helpful. So I'll turn it over to Mike to get us started on the first part of the rule, the definition of advertisement.
Thank you very much, Emily. Look, jumping right in, I think that it's very important to understand the definition of this term advertisement under the rule at the outset, and really before we take any steps into the substantive requirements or prohibitions within the rule, because the definition of advertisement will tell us when the specific anti-fraud provisions of this rule apply, to be distinguished from other types of communications where what I will call general anti-fraud prohibitions within the Advisors Act apply. A good way to look at this is that an investment advisor, as a fiduciary, should never mislead or defraud its clients or make any statements that are materially inaccurate. And if they do, Emily and her colleagues may come find you and take action, but only with respect to a limited universe of communications do we need to worry about the very specific requirements of this rule. Now, I called it a limited universe, but as we will discuss, it's actually a broad universe of communications, but it's not all communications coming out of an investment advisor. Jumping into the definition itself. Unlike the prior version of this rule, there are now two prongs to the definition of advertisement rather than one prong, and you see them both here on the screen. The first prong is much more similar to the definition of an advertisement under the current version of the rule that I'm going to assume most of us are familiar with, and it defines any. And let's go back to the prior page for now. It defines any direct or indirect communication by an investment advisor to more than one person, and we'll talk in just a moment about hypothetical performance, that offers advisory services with respect or with respect to securities to investors in private funds, if those private funds are advised by the advisor. It also covers communications to existing clients or investors in private funds that offer new investment advisory services with respect to securities or investments in private funds. There are a couple carve-outs and carve-outs to those carve-outs and limitations to the first prong, and we will address them momentarily. But before we do, I want to address the second main prong, which is now any endorsement or testimonial for which an advisor provides compensation directly or indirectly to the third party providing the endorsement or testimonial. An endorsement here is any statement of approval or solicitation by a third party who is not a client of the advisor, and a testimonial is any similar communication, statement of approval, or solicitation for investments with the advisor that is provided by an existing client of the investment advisor, and they are treated substantially the same way. Now, I think it's important that we really dig into some of the language around these rules and talk about some of the carve-outs. The first one that I think we need to address here is the treatment of hypothetical performance information. As you can see from the definition of the rule here, and Emily, I may ask you in just a minute what the staff and the commission were looking to achieve by treating hypothetical performance this way, that a communication that includes hypothetical performance, subject to some limitations, is going to be treated in advertisement, even if it is provided to only one person. And there appears to be there a policy decision that hypothetical performance may be of a higher risk than much of the other types of information that's going to be included in advertisements. The second point that I want to make while we're on this page is the use of this term direct or indirect communication. And I think this is very important because it, in essence, documents within the rule concept that that has been applied by the staff for many decades, and that is that investment advisors should be subject to this rule, whether they publish a communication and disseminate that communication to multiple prospective investors and prospective clients, or if they cause a third party or an agent to do so, an affiliate doing it on their behalf, or any other arrangement where the investment advisor is either entangled in the creation of the communication or in the alternative has adopted some statement of a third party as its own. All of those concepts are built into this terminology, direct or indirect communication. And really what we're looking at here is an effort to avoid circumvention. If you are involved in creating a communication that markets your services or your private funds and it is disseminated to the public, it generally will be treated as an advertisement. The next point that I want to make here is this notion that the communication must offer advisory services or offer investments in private funds advised by the investment advisor. And this is an important point that I think a lot of people aren't quite catching on to. And the notion here is communications by an investment advisor that don't contain an implicit or an explicit offer of services are not subject to this rule. And that makes sense when we think about something like an offer of employment. It's not an offer of advisory services. So if you are making job postings, they really shouldn't need to go through your compliance department, at least as it pertains to a marketing review. If you are highlighting, if you're making just very general brand recognition communications, if you place the name of your investment manager in a baseball park or a stadium, that's not going to be considered advertising under this rule because it's not actually offering explicitly or implicitly offering services. Another good point would be white papers. Now, people should be careful here because sometimes I see the term white paper used and we're talking about commentary on the markets or commentary on different approaches to investing from an academic perspective. And if those communications don't contain an implicit or explicit offer of advisory services, they won't be advertisements. But I think that advisors need to exercise caution when dealing with white papers because in practice, and John, I'm sure that you've seen this in your career, a lot of communications that are characterized as white papers will include an academic concept or market commentary, and then wrap up with a statement like, at McGrath Advisory Services, this is one, the ability to use these principles are one of the reasons that we outperform the market and you should invest with us. it becomes very challenging to consider those as white papers when they include that sort of statement, because that sort of statement would transform the communication into an advertisement. So with all of that said, I do think that we should also address some of the carve-outs that are present within the first prong of an advertisement. And I also want to say, don't forget about that second prong, but Emily is going to do us all the favor of explaining it to us in greater detail in a couple minutes here. But if we focus on this first prong, more traditional advertisement communications. Katie, could we go to the next page? Thanks. So first, as we noted, one-on-one communications are excluded in this first prong of the definition unless the communication includes hypothetical performance information. But there is a carve-out to that carve-out such that if you have a one-on-one communication either to a private fund investor, to be distinguished from an advisory client or a separate account client, or in the alternative, in response to an unsolicited request, either from a private fund investor or from a separate account client or prospective client, then the communication will not be considered an advertisement, whether or not it includes hypothetical performance information. So if we take all of those carve-outs from a comprehensive perspective, really what it means is you can rely on the definition of an advertisement requiring or the limitation that an advertisement is only a communication to more than one person, unless you at your own initiative and not in response to a specific unsolicited request are pushing hypothetical performance information in a one-on-one communication. That is really the situation where the communication will be an advertisement when it otherwise would not be. The next point that we need to make is that—
Mike, can I ask you a question?
Yeah, absolutely.
On the one, because I know this was addressed in the adopting release. I think Emily pointed out there's a lot of great information, and there is. Can you just talk for a second about one-on-one and what really qualifies as one-on-one? Because I know, from a practical perspective, I have marketing telling me from time to time, that well, it looks like a standard deck to me. Well, but we're using it with this client, so we're using it one-on-one with this client, and they're trying to call that a one-on-one.
So that's not a one-on-one communication. There was a concept where that mattered as a one-on-one communication under the current rule and guidance that I believe was in the ICI 2 no action letter. That concept is left. We'll talk about that a little bit further. A one-on-one communication is a communication, the content of which is used with one prospect, okay? And what that means is if I have a marketing deck and the deck is used in substantially the same way in 20 different one-on-one communications, from the perspective of the SEC and the staff and this rule, that's 20 communications of the same content. It is an advertisement. By contrast, if John Amundi has a very large client to which you're devoting a great amount of time to try to get them in the door, and you create information that is tailored to that prospect, and you communicate that information only to that prospect, that's what we mean by one-on-one, not canned language or scripts or books that, even if they're only used in a one-on-one communication each time, get used on multiple occasions. We look to the multiple uses rather than the way that they're communicated on each individual occasion. One other point that I will make, though, is oftentimes a prospective client or a prospective investor is actually going to be several people, right? So we're looking back to that large client that Amundi is considering, John, let's say it's CalPERS, and when you sit down with CalPERS, there may be 3 people from the investment arm, 2 trustees, and also 3 representatives of a consultant who are there representing CalPERS, right? And I lost track of how many people I mentioned, but all of them would be considered one client in this scenario because it's all one prospect. They're all acting on behalf of the same single client. So don't look to the number of natural persons, look to whether it's a communication to one prospect when assessing whether it's a one-on-one communication.
Great, thanks.
Yeah. The next point that we want to make is around we're using the term extemporaneous live oral communications. And there's an express carve out for extemporaneous live and oral communications. And what this really means is, to the extent that we are sitting down person to person, or the extent that we're on a live webinar, that's not being recorded and redistributed, and personnel from your investment advisor make statements in that context, not scripted, and not reproduced and recirculated. Those statements that are extemporaneous, that are presented in a live manner, will not be considered advertisements. People need to be careful here, because if you take the same webinar or you take the same presentation that was initially oral and initially extemporaneous, you record it and you redistribute it, then that redistribution will be treated as an advertisement, even though the original extemporaneous statements would not. And that's something to be very, very careful about, and an area where I see some confusion, and where advisors need to ensure they have a good understanding of this exclusion. Finally, information contained in a statutory or regulatory notice or filing or any other communication required by law or regulation will not be considered an advertisement, again, provided that it's reasonably designed to satisfy the requirements of that filing. So, Emily, I will put to you, if in my ADV I elect to add, because I can add whatever information I want to the ADV as long as I satisfy the requirements, I elect to add the investment performance of my best performing strategy and say that it is representative of the services that I provide to clients. How would you look at that from the perspective of the staff?
Yeah, that's a good question, Mike. So, the requirement is that the information has to be reasonably designed to fulfill the requirements of the regulation. So the ADV has, specific questions that they're asking for answers designed to address those questions. Any information that's not directly in response to those questions, like as you said, performance information about a separately managed account or a private fund, that would fall under the definition of advertisement. That would be an advertisement. That would not be eligible for the exclusion, but it wouldn't make the rest of the form ADV an advertisement. Just that portion.
Okay, great. That's actually, I think, a very important point. Could we apply that same notion that if certain information within a communication is considered to be an advertisement, but other information in the communication is not, is that relevant in any other circumstances? So, for example, there's a passage in the rule release which you recommended that everybody read, and I endorse that. I think it will be very important for legal and compliance professionals to read the release. There's a passage in the release that relates to PPMs for private funds, and it suggests that within a PPM there will be sections that describe the terms of the offering, and also within a PPM there may be other sections that describe other information about the private fund or its manager. If I have a PPM and in that PPM I include the performance of predecessor funds in the program, how would that be treated, and how would that section within the PPM be treated, and would it impact the rest of the communication?
Yeah, I mean, Mike, I think the same principle applies there that would apply to the Form ADV. So that information wouldn't be reasonably designed to meet the requirements that an advisor put in its PPM. So that the related performance information, that would be an advertisement, most likely. But the information designed to meet the requirements of the law would not.
Okay, so John, yeah.
Well, I was just saying, and I assume that the same would apply then, not to keep going back to one-on-one, but would apply in a one-on-one, because to Mike's example of a large client that we're trying to onboard or to woo, we'll have some slides that are going to almost always be standard slides, whether they're performance or other information about the strategy, but there will also be slides that are unique to that individual client. So I can really bifurcate that presentation, and some of it is going to be advertisement and is subject to the new marketing rule, and some of it's going to be one-on-one that, while I may have it packaged together, it's not going to be considered from the marketing rules point of view.
John, I think that's right. Unless Emily wants to interject and tell me that she disagrees. And I think that you should also consider, and other people in similar situations should consider, that this principle applies not only with respect to required communications, PPM, one-on-one communications, but also in response to unsolicited investor requests. sometimes I receive questions from clients that would suggest that their understanding is if they get a request for information from a client, that no matter what information they include in the response, that the response is not an advertisement. And again, this is an issue addressed in the adopting release, and it's addressed in a manner that shows that that's not quite right. Right? To the extent that in response to an unsolicited request, you are using canned language from an RFP deck that you've used on multiple occasions, or you are including a presentation that is responsive to the request, but that same presentation has been used in multiple other situations, those parts of the response will also be treated as advertisements.
Thanks, Mike. So why don't we send it back over to Emily? She can provide just a brief overview of the general advertisement prohibitions.
No problem. But there's one thing I just wanted to add on the definition of advertisement, and I'll get into this when we do testimonials and endorsements, but the second prong of the definition is actually a little bit more broad than just advisory, offers of investment advisory services. So if you're paying somebody to make an endorsement about the advisor, and the endorsement could be as broad as just describing its experience with, or describing what the advisor does or the experience, or describing something about the advisor, or endorsing the advisor. It doesn't have to be offering. It doesn't have to be offering the advisor's investment advisory services related to securities. It could be broader, but we'll get into that. So let me get into.
Well, Emily, if I may, while we're bringing up things that we missed, right, for good measure, I think it's also, we haven't said it here, but you will note that the definition, the first prong, defined within scope of advisory services, communications, or within the scope of an advertisement, communications related to advisory services and communications related to private funds, right? Conspicuously absent would be registered funds, CITs, non-US funds like UCITS and AIFs that are not marketed to US persons, or other types of investment products that are not advisory services or private funds. Very important that people keep that in mind.
All right. So let me do a quick overview of the general prohibitions, and then we can have a similar discussion about that. So there are, the rule has 7 general prohibitions that cover certain broad categories of advertising practices that the commission believes are associated with significant risk of being false or misleading. So these are principles-based prohibitions that are meant to address these broad categories of potentially misleading conduct. And then at the end, there's a general anti-fraud sort of catch-all provision as well. One point here is that all advertisements, whether they meet the first prong or the second prong of the definition, all advertisements are subject to the general prohibitions. They cannot violate them, even if they comply with the specific conditions, for example, related to performance or related to testimonials. They still also have to not violate the general prohibitions. And another sort of broad overarching comment is that in order to demonstrate that an investment advisor violated the general prohibitions, it's important to note that the commission only needs to show that the investment advisor acted negligently. So let me just go through what they are. They're kind of broadly listed on the slide. The first is that an investment advisor advertisement can't include an untrue statement of material fact or be misleading by omitting to state a material fact. And that's kind of just a paraphrase. The second is that the advertisement can't include a material statement of fact that the advisor does not have a reasonable basis for believing it will be able to substantiate upon demand by the commission. The third, again, gets to misleading advertisements. An ad can't include information that would be reasonably likely to cause an untrue or misleading implication or inference to be drawn concerning a material fact relating to the investment advisor. The fourth has to do with risks and benefits presented in advertisements. An advisor's advertisement cannot discuss any potential benefits, generally speaking, without providing a fair and balanced treatment of any material risks or material limitations involved or associated with those benefits. And then the next two, so 5 and 6, are really meant to get at cherry picking. They're meant to get at cherry picking activities that would result in a non-fair and balanced portrayal of first, investment advice, and second, performance results. So if an advertisement includes a reference to specific investment advice provided by the advisor, the advice has to be presented in a manner that is fair and balanced. And then the advertisement cannot include or exclude performance results or present performance time periods in a manner that is not fair and balanced. And like I mentioned at the start, there's also this catch-all last general prohibition that the advertisement cannot otherwise be materially misleading. One final note here, and then we'll open it up for discussion amongst the three of us, but a lot of this is sort of facts and circumstances based on the context of the advertisement. And so an advisor that is looking at these general prohibitions is going to have to determine whether or not a statement is false or misleading based on both the context, and then they can also take into account the nature and sophistication of the audience. So let's see if we have any questions to start us off.
I have a question that I think will start a good discussion here. There's been a lot of chatter, a lot of talk about how these principles-based prohibitions in many respects will provide greater flexibility to investment advisors as compared to a more prescriptive approach under the prior version of the rule. What are some areas where these changes should provide more flexibility to advisors?
I mean, I think the first and kind of headline item from the adopting release is that testimonials are no longer per se prohibited. So while the commission also has conditions that they place upon testimonials, they're allowed so long as they don't violate the general prohibitions, so long as they're not false or misleading or lead in misleading implication or inference. And we can get into more specifics about that in a sec. And then past specific recommendations. I understand that they had previously been addressed by, they were per se prohibited under the rule, unless there was a very, very specific disclosure of all of the recommendations within a time period. And then I understand that there also had been no action letters in that area. But what the commission did was lift the per se prohibition and allow past specific recommendations, which are just, the commission made it more easy to understand by just calling it specific investment advice, and allow that subject to the general prohibition. So, taking into account the context and the audience, and providing the appropriate disclosures, that would be allowed.
So, Emily,
Okay.
Can I ask, and I don't know if you'd be in a position to answer now, because I know that there's a discussion of the SEC identifying which no action letters will be rescinded. But for the past specific recommendations, where in the guidance that was provided under no action letters, if you were providing a positive example, as long as you were balancing with a negative example, and I know that there were numbers involved there, either 5 or 10. But now under the fair and balanced, will you still be required? Can you provide just a positive example and not a negative, and or will those no action letters and those parameters still be in place?
So you're right that the no action letters are on the list of the specific ones that address past specific recommendations are on the list for staff review to rescind. And what the commission said in the release, however, is that the steps that an advisor took in those letters could still be applicable as a means here of providing a fair and balanced portrayal of a specific investment advice. But I think the point being that those might not be the only way to satisfy and make sure that it's the advertisement's not misleading. There could be other ways. Providing just your best is not going to be fair and balanced. And the release goes through some considerations of disclosures and context and information that an advisor might need to include to make that fair and balanced. Mike, I don't know if you have any practical tips on that and what you're seeing, if you want to share.
I do. I think that one aspect of considering what is fair and balanced that was discussed in the release that I think is very important for people to pay attention to is that the sophistication of the target audience is one of those considerations that are appropriate to take into account when determining whether a communication is fair and balanced. And consequently, the degree to which an advisor should include disclosure or should include context or may feel the obligation to balance a discussion of a good investment with a an equal number of bad investments or to try to approach it in a different fashion. All of that should be taken under consideration, but in the context of how sophisticated the party that you're presenting to is, right? What other information is in the communication? How proximate is it to what you are communicating? Those things matter, but it would be certainly, in my view, having read through this, it would be wholly appropriate for advisors that have relationships or services that they provide to both retail, less sophisticated investors, and also to very sophisticated institutions to have a flexible standard or multiple standards depending on the sophistication of the institution or the targets with whom they're communicating.
I mean, I think that's fair, Mike. I think it all comes under one standard, though, but it's just on how it's applied. The commission did say in the release that an advisor could take into account the nature and sophistication of the audience. That's true.
Okay, Emily, you want to move into testimonials and endorsements and provide a brief overview of some of the specifics that would be required there?
Sure. All right, so this part of the rule is the commission imposed certain conditions on the use of compensated and uncompensated testimonials and endorsements. As I mentioned, and Mike mentioned early on, the concept of testimonial and endorsement is sort of how it's traditionally seen, and how the commission no action letters have treated it in the past, but also when the commission merged the cash solicitation rule or merged the activities under both rules, the definition of testimonial and endorsement was expanded such that it includes paid, compensated, not just for cash, but cash and non-cash compensated testimonials or solicitations and referral activity. So that's now, so when we're talking about testimonials and endorsements, we're talking about how they are traditionally plus compensated solicitations and referrals. Just wanted to state that up front. So an advisor may not include a testimonial or endorsement or pay someone for a testimonial endorsement unless the advisor satisfies the rule's conditions. And as I noted before, in addition to the conditions, the advisor also has to make sure that the advertisement or the paid endorsement doesn't violate the rule's general prohibitions. So there are three categories of conditions, and I'm really trying to break this up on a higher level because they do get into the weeds. So the first category of condition is disclosure. There are two layers of disclosure. There's a high-level disclosure, and then there's sort of more detailed disclosure. And the high-level disclosure is what needs to be displayed clear and prominently in the testimonial. And we can talk about that in a sec. And so these high-level disclosures are really getting at, like, is the testimonial made by a client, a non-client? That's kind of what it's getting at. And then also, is the testimonial endorsement paid for or compensated by cash or non-cash compensated? If applicable, the advisor would have to state that. And then also, if there's a material conflict of interest, the advisor would have to put that in the high-level disclosure. And then there's there's a second layer of disclosure, which is not required to be displayed clearly and prominently, but is a little bit more detailed, and more details about the terms of the compensation, and more details about the material conflicts. The second condition is investment advisor oversight and compliance. And so these are that the advisor has to have a reasonable basis for believing that the testimonial or endorsement complies with the requirements of the marketing rule. And then there has to be a written agreement with any person, between the advisor and any person giving a testimonial or endorsement that describes the scope of the activities and the compensation. There are some partial exemptions that I'll cover briefly where these are not required. And then the third condition is the disqualification condition. So an investment advisor cannot compensate a so-called bad actor for a testimonial or endorsement. And there's a list of disqualifying events in the rule. And that's kind of what I mean when I say colloquially bad actor, a person that is disqualified under the rule. And so I would suggest that people take a look at that list, and it's a little bit different from the prior cash solicitation rule. So just, that's something to look at. And then there are a couple of partial exemptions. And I just want to make it really clear that these are not exemptions from the marketing rule. They're not even exemptions from having to comply with the conditions. They're partial exemptions from having to comply with certain conditions. So I just want to make that clear. I'll highlight two of them. There's the de minimis or zero compensation partial exemption, where an investment advisor is exempted from the written agreement and the disqualification provision if the advisor pays below the de minimis threshold in cash or non-cash compensation for a testimonial or endorsement. There's also a partial exemption for affiliated or in-house solicitors. So like in-house investment relations people, for example, or people at affiliated firms who are compensated by the advisor for making a testimonial endorsement. Those people are exempted from, the advisor is exempted from disclosures and written agreement with respect to those testimonials and endorsements. There are also a couple of partial exemptions for broker-dealers, depending on whether they're registered and subject to the Exchange Act disqualification, whether they're subject to regulation best interest, and whether they're acting as a covered person under Rule 506 of the Securities Act. So there are a bunch there, and I urge people to take a closer look. I don't think we have time to get into all of them. So with that said,
Emily, can I jump in? I have a bunch of questions based on what you just shared with all of us, and I want to pepper you with all of them, really. I think the first one is you mentioned, I think you used the term a de minimis or zero compensation exception with respect to the de minimis compensation. I would have thought that an entirely uncompensated testimonial or endorsement would not be treated as an advertisement and would not be subject to these restrictions if someone just went off on their own and gave a testimonial or an endorsement without my knowledge or involvement. Is that right?
So that's a tricky area. And I'll start by saying that there are two prongs of the definition of advertisement. If you have an uncompensated testimonial or endorsement, it's not going to meet the second prong. So in order for it to be an advertisement, it has to be it has to meet the requirements of the first prong, offering the investment advisor services with respect to securities. So that's kind of where I think you narrow it a little bit. So we're not just talking about somebody, out in the ether making a testimonial.
Right. So to make sure I understand it right, then a client of mine says something very nice about me, and I don't know that they are doing it. That's not an advertisement. But if they say something very nice about me and authorize me to republish that in my books and in my fact sheets, then it becomes a testimonial that is subject to the first prong of the rule. Does that sound right?
Mike, I'm not saying this to avoid your question, but you cut out in the second part of your question. So they said something very nice, and then I didn't hear what happened next.
They said something very nice to a third party, and I didn't know about it, and I didn't pay them to do it. And that would not be an advertisement. But then if I find out about it and they authorize me to republish it in my own communications, then it becomes an advertisement subject to that first prong of the rule. And because it is now an advertisement, it would be subject to these requirements.
Yeah, okay. I agree.
All right. But I have more questions.
Yes.
I think the first question I have here is, I believe I heard you use the term reasonable basis when talking about the degree of oversight and compliance that an investment advisor needs to exercise over compensated promoters, right? People giving either compensated testimonials or endorsements. Exactly what does that mean? How can a person go about developing a reasonable basis? Is this in practice absolute liability if a promoter says something that is inconsistent with the rule, or are there circumstances where an advisor may have exercised appropriate oversight, not caught a communication, and wouldn't be liable for that communication?
That's a good question. So yeah, there are two parts here. There's you're talking about the oversight, which is our commission.
A similar question comes up, I think, if I am compensating someone who turns out to be a bad actor, but despite my efforts, I didn't find that. I couldn't figure it out.
Yeah, I mean, I think there is a reasonable basis standard built into both of those parts of the conditions that you're talking about. And I think, one thing to mention is under the old cash solicitation rule, the bad actor provision was, there was no qualification at all. It was strict liability. Sorry, that was the word I was looking for. And under this rule, the commission did add a reasonable basis provisions, and the commission talks a lot in the release, both with respect to the bad actor and with respect to oversight over the kinds of things an advisor could be doing. But of course, because it's a principles-based rule, the commission is not prescribing certain activities that are necessarily going to satisfy the reasonable basis standard. It provides a range of activities, and I guess I would turn it over to. And sorry, just to complete the thought, it provides a range of activities that might be tailored based on the risk of the risk of the person making the compensated or uncompensated testimonial or endorsement, and the risk of the person being a bad actor. So, I mean, I'm curious as to how, I guess from John's perspective, what you would see as the types of things you would look for, or Mike, what are you seeing with your clients?
So from my perspective, I mean, and since we haven't even gotten there yet, it's a little harder from the practical perspective because, again, we're not there. But I think some of the things that we would consider would be the reputation of the individual, the extent of time that we've either had them as a client or been engaged with them, and an understanding of what their background is as well, in order to be able to establish some of that. But I would say, I guess Mike probably has a better idea from the legal perspective.
I don't know if it's better, but I do have views. I have been cautioning clients that in most cases, simply gathering certifications or attestations probably is insufficient, or maybe insufficient to meet this reasonable basis standard. The way that I view this is that's going to be a base from which you want to build a reasonable basis. And so in addition to a certification or an attestation from the promoter, it would be important to do something else. And that may be training, that may be a prior review of communications, it might be an after the fact spot review of communications. And that gives you the benefit of approaching things from multiple angles. And I think also over time, to get a better sense for whether your training or your contractual agreements are being adhered to. If you have a history of a positive experience with a particular promoter over the course of 4 years, that might be a reasonable basis to say we don't need to exercise as great a degree of oversight. And by contrast, if you've gone through trainings and you have contractual protections and you get certifications, and every time that you do an after the fact review of their communications, you find something wrong, that's probably a red flag that you need to exercise greater oversight. So really what I try to suggest is, as Emily pointed out, this can be flexible depending on the facts and circumstances, but your base approach should be certification plus. And what are you going to do in addition to certification based on those facts and circumstances to show that it's reasonable if you're called to do so?
Thanks, Mike. That's really helpful. I do want to move into performance advertising, but just one other question on the attestations. Do you think there's additional questions that that firms could add to their existing attestations that would kind of get them in compliance with this rule, in addition to the plus that you just discussed?
Well, I think that places to start would of course include an attestation that the person is not a bad actor, and I would include either within the attestation or in materials that I sent with the attestation a list of those things that would be disqualifying, so they know what they're attesting to. Certainly, the attestation should include that they haven't in the past, and they will warrant that they will in the future not take actions that would be inconsistent with the rule. And I would include in that attestation, similar to the list of disqualifying activities, a summary of exactly what it is they are attesting to. I would be concerned if I was sitting in the chair that Emily is sitting in, that there are promoters out there who are giving an attestation that is 2 sentences long and may not be in a position to understand exactly what it is they're attesting to. Show that they are giving that they understand what they are attesting to, and the attestation, I think, is more reliable.
Thanks. Should we move into performance advertising, Mike?
Sounds good to me.
Great.
Okay. Now, notwithstanding that the rule in many respects has become more principles-based, and there's been a removal of certain prescriptions that were present in the current version of the rule does contain a series of express prohibitions with respect to the presentation of investment performance. And a lot of these are very technical, and I think that managers will find some of them to be very challenging, particularly because they change the state of play, especially for institutional managers. And it's important to understand all of these changes. So I'm going to run down the requirements piece by piece. I'm going to try to do it very fast and highlight some of the key differences and practical considerations. So the first one here, the big piece of news, is that gross performance may only be included in an advertisement if net performance is also included. And the net performance needs to be included with equal prominence, presented in a manner that facilitates comparison between the two, and it needs to be shown also for the same time period and using the same calculation methodology. And under existing no action letters, a lot of investment advisors that have sit-down one-on-one presentations with sophisticated institutions are in the practice of showing gross performance without net performance. That will need to end with respect to advertisements. This is a big change. I also think that as of right now, there are some questions around the presentation of net performance that I find challenging to answer. I may even go out on a limb here and ask one or two of Emily. And the first one is, if we're showing actual investment performance that was obtained either on a composite or a fund basis, it's pretty clear what net performance is and why this is important. But I think there are also a couple of manners of presentation that don't lend themselves well to the presentation of net performance. And an example that I would use is it's very common for private equity managers or real estate managers to show on a page all of the investments made by a fund and show the performance of each of the investments on a gross basis. And then at the bottom of the page, sum all of those investments up to demonstrate both the gross performance and the net performance of the fund. And this is a challenge because if we were to try to demonstrate the net performance of each of the individual investments in a fund that aggregates performance for purposes of imposing carried interest or some other form of performance-based fees, the net performance isn't really meaningful and it's not really accurate. So Emily, I would ask you, and recognizing that the staff really can't be in a position to give guidance on everything, is this the sort of situation where either simply showing the net performance at the bottom of the page would be acceptable, or perhaps where the staff might be in a position to give more guidance?
Thanks, Mike. I think for questions where the literal requirements of the rule cannot be complied with, practically speaking, for advisors, that might be the kind of question where it would be fruitful to talk to the staff, on a one-on-one basis. And if you look at the kinds of FAQs that the staff has put out so far on the marketing rule, you'll see that at least one of the two is really about a similar situation where we were made aware that firms could not comply with the 1, 5, and 10 requirement, practically speaking, because there was a lag time between the end of their most recent calendar year end and when their performance results came out. And so that's the kind of question that it might be more fruitful to come to the staff with one-on-one. Just, as a PSA, kind of other questions where, there's a principles-based rule and people are coming asking us to draw lines that might not be as fruitful because, of course, the commission drafted a principles-based rule and specifically left a lot of the determination up to advisors based on their facts and circumstances. And I don't know that the staff is necessarily going to vet individual facts and circumstances to provide comfort. So I guess that's what I would say in response to your question.
Okay, thank you. I think we'll use that as a segue to talk about the required or the prescribed time periods. So the next key requirement in the new rule here is that if a communication that is an advertisement includes investment performance, it must present that performance in across 1, 5, and 10-year periods. And that is applicable to any communication that markets advisory services, but it is not required with respect to the performance of private funds. Now, a couple questions often come up with respect to this requirement. The first one that we always get is, can you show different periods? And the answer is yes. If you show 1, 5, and 10, you can also show 3 years, you can show 20, you can show your inception to date performance if your inception to date performance is prior to 10 years. Another question that comes up, and this is actually stated in the rule, is what if we have less than 10 years? Well, if you have less than 10 years, the answer is quite simply replace the 10-year performance with your inception to date performance. If you have less than 5 years, replace the 5-year performance with your inception to date performance, as you typically would in these types of presentations. Another question that often comes up, and a point of confusion here, is that the 1, 5, and 10-year prescribed time period requirement is only a requirement that this information be included in an advertisement. It is not a requirement like the net performance requirement that it be included with equal prominence and in a manner designed to facilitate comparison and across the same time periods and with the same methodology. Now, that said, I will never put words into Emily's mouth, but I will surmise that she could be frustrated if an advisor sought to satisfy this requirement by placing 1, 5, and 10-year period performance on page 78 of a presentation when pages 1 and 2 happen to cherry pick periods of time during which the strategy performed very well. And the way that I would look at that is that although the staff will not answer questions about what is fair and balanced, I would advise any client that would be unfair and imbalanced because it's really highlighting good performance, but showing the context of the extended performance period, hidden on page 78. And John and Emily, I'll ask if you have any questions or other things that we should talk about when we talk about the prescribed time periods before moving on to our third big ticket item, which is hypothetical performance.
Nope.
All right, hearing none, let's move on. Hypothetical performance, there's a lot going on here. And I think that the first thing to do is to provide a definition of hypothetical performance. Now, hypothetical, and I'm not going to read the definition, I'm going to paraphrase here, is really any performance results that were not created or that were not obtained by a client of the advisor or a private fund managed by the advisor. And that we need to interpret that in a manner that will expand the universe of things that we consider to be hypothetical performance. So it obviously includes back-tested information. It obviously includes model performance. It is also going to include what a lot of private equity managers will call track records. And that's a practice where a manager may pull all of the transactions that were concluded in Europe across a whole bunch of different funds and aggregate all those transactions and create a performance record from multiple funds. So we're picking and choosing transactions from multiple funds. That will be hypothetical performance information, even though the transactions were actually done on behalf of clients. It also includes performance projections. It also includes, I will admit somewhat to my chagrin, target performance or statements of what an advisor thinks it may be able to achieve with respect to any individual investment strategy. In all of these scenarios, there are three elements that must be satisfied for an advisor to show hypothetical performance in an advertisement. Number one, we have it here on the page, the advisor needs to implement written policies and procedures that are reasonably designed to ensure that the performance is relevant to the investor, that it's relevant to their financial situation, that it is relevant to their investment objectives. And this can be done differently depending on the intended audience. You don't have to have one standard that you apply to every audience. You don't even necessarily have to have one standard that you apply to each type of hypothetical performance information. It may be appropriate to determine that less sophisticated investors could see target performance, but really sophisticated investors only could see back-tested performance. But the point is, you need to have written policies and procedures that ensure that you are only showing this performance to people for whom it is relevant, and that it can be understood really by the audience that receives it. The second requirement, and we don't have this on the page, is a requirement that you describe the risks of an investor relying on hypothetical performance information as information that could potentially project the future or be representative of a past strategy. I think that most people on this webinar have seen these types of disclosures, talking about how it's not real performance, talking about how the actual activity of managing portfolios might create liquidity constraints, or that it might influence the types of decisions that would have been made by an investment professional in those circumstances. Those sorts of cautionary disclosures need to be included. And number three, there is a requirement that the methodology and the assumptions that were used to calculate the hypothetical performance be provided to the investor. And this would mean if you are showing a back test, that you call it a back test, and on top of that, you describe what process you went through to achieve that back test. And this will look very different for any individual back test and any individual model. What I would suggest to managers is that they do not seek to have one set disclosure, one model to describe the assumptions and methods of their hypothetical performance, because this should be tailored to each hypothetical performance stream so that you're actually describing what people are looking at. Any questions on this, or should we move on? Hearing none, we'll move on. So the remaining requirements here, I'm not going to spend quite as much time on. They are very important, but I think that the net performance, the time periods, and the hypothetical performance are where managers should be first focused, and then consider whether these remaining issues are relevant to them. First, related performance. Now, related performance is the performance of one or more related portfolios, where a related portfolio is a fund or account that is managed in a substantially similar fashion to the product that's being offered. You may show related performance, but it is only permitted if you do one of two things. First, include all of the related portfolios, all of the portfolios that you manage that are substantially similar in character. And this is what you would do, for example, if you were a firm that claimed compliance with GIPS. In addition, you may also show the performance of one or more related portfolios if that performance is not materially higher than it would have been if all of the related portfolios were included. So this introduces a tough question. If you're only using one representative account, how are you going to know whether that rep account performance is materially higher than what the composite performance would have been if you showed all of the related portfolios? In most cases, I think that managers will be in a position where they want to have a new procedure in place that compares rep account performance or compares the performance of any subset of a full composite performance to ensure that they are not inadvertently or deliberately cherry picking portfolios that are materially better than the whole composite. Next, we come to extracted performance. Extracted performance is a very precise definition. The extracted performance is the performance results of a portion of one total portfolio. So this is, for example, some people call this segmented performance. I just like to use the example of if there is a portfolio that has a mix of stocks and bonds, if you show the performance of only the bonds, this is a good example of extracted performance. Extracted performance could be thought of as a type of hypothetical performance because nobody actually obtained it, but a less risky type of hypothetical performance such that the requirements that would otherwise be required for hypothetical performance are not in place. Instead, the advisor only needs to show either the performance results of the total portfolio from which the extract came, or in the alternative, offer to promptly provide that information. I would also warn that you need to keep in mind your obligations that the entire communication be fair and balanced. You don't want to be in a position where you extract only top performers from a portfolio and then in 6-pin font offer to give the entire portfolio. There are ways that that could go wrong. A point that I do want to make here, though, is that extracted performance looks like those who are familiar with GIPs would call a carve-out. And technically it is. The problem is, if you have a composite and your composite includes one or more carve-outs, along with other carve-outs or other portfolios, that composite performance will be treated as hypothetical performance under this rule. And that's because it's only extracted performance if it's extracted from a single portfolio. This is another area where, Emily, I think that you and your team might see some requests for FAQ guidance come in. But I won't try to put you on the spot here as to how you would approach that, unless you want to offer.
I mean, no, I think that the release is fairly clear on this point, that if it's an extract, if it's a composite of extracts, the commission does not view that as actual performance of a single strategy, and it would treat that as hypothetical. So I do think it's at least stated in the release that way.
Right. Okay. Now, finally, we will note that you cannot say that the commission approved your calculation or presentation of performance. And finally, I will touch briefly on portability of performance. This, I think, is a very important issue for certain managers. And what's happened here is that performance portability, and this is a situation where a team of portfolio managers have joined your firm, and you want to show the performance that they produced while they were at a prior firm, or perhaps you went through a merger or an acquisition and you want to show the performance of one of the predecessor entities. Predecessor performance previously was addressed through no action guidance, and what happened here is that the commission looked to the no action relief that had been in place and adopted within the rule standards that look very much very similar to that no action relief. The problem is, now that these standards are written into the rule, they are, from my perspective, fairly rigid about the circumstances that need to be present in order for predecessor performance to be shown in advertisements. In essence, the requirements are that the persons or the person or the group of people who were primarily responsible for achieving prior performance continue to manage accounts at the new advisor, and also that the accounts that are managed at the old advisor and at the new advisor really are substantially similar, such that they will provide meaningful information to the recipient of the advertisement regarding the services that are offered now. I will say that the concern that certain managers may run into, and that they should consider if they have predecessor performance in their advertisements now, is that the continuity of portfolio managers or other people who are responsible for that performance extends both backward-looking and forward-looking, such that if after the time that a team joins the new advisor, there is at a later point turnover in that team, under the rule as written, you may run into a situation where performance that the advisor has shown, including for many, many years, may become performance that can no longer be shown due to that turnover. I know that we are tight on time, so it probably makes sense not to talk about that further, but to field any other questions that we have on performance issues before we go on to practical considerations.
No, that's great. Thanks, Mike. I know there's a lot to unpack there. Let's turn it over to John, and we can discuss some practical considerations as we look towards implementing this rule.
Thanks, Justin. Sure. So I think everything that we've heard so far is great, and the advice that we can get from the SEC and from a law firm. Hopefully, I can bring a little practical firm experience and talk about some of the things that we currently do and things that we're looking at as we look to adopt the new rule. So starting with the review and approval process, I think we all know at this point that the SEC did not adopt that requirement for investment advisors to review and approve prior to dissemination. I want to talk a little bit about why, but then where that leaves us. I think the SEC got a lot of comments on this aspect of the proposal, some just noting the burden of actually trying to implement a process like that, or that it might slow down their communication time. But I think one of the most notable comments, and I think that the staff agreed with, was that it would be duplicative of an existing standard under the Compliance Program Rule 20647 for investment advisors to have policies and procedures. And I'm paraphrasing, but for the accuracy of disclosures made to investors and advertisements. And so we all already have some type of process in place for supervision of that. It was just a matter of, did we want to move to a pre-review perspective? And I think at this point, we know that wasn't the case. So now what do we do going forward? What becomes our consideration? For me, and the way I've thought about it, it became more of a how and a who exercise. Starting with the how, it was, there's no required procedure, but the SEC did note that there should be objective and testable compliance policies and procedures. So each firm can choose their own how process, and there are a lot of different considerations there, whether it's pre-review, post-review, spot check, and any of these options can be combined and tailored based on various factors, from risk assessments and complexity of the offering to, I think we've talked about a few times already, audience that you're presenting to and what that might imply as well. But the one thing that is clear is that no review is not an option. And so I think we all need to think about, if we haven't had a really well-established program, that now is the time to really start to look at that. And then you have to move into, okay, who's going to do that within the firm? Is it compliance? Is it legal? Is it sales or marketing? Although in a self-sign-off process, I'm not really a fan. Because I think on some level, first of all, anytime that we create something, we think we do a good job. And so if marketing is signing off on their own materials, probably not the best person to ask if it was fair and balanced. But then the other thing is, what training and experience are they going to need? The proposal did have a consideration when they were looking at the pre-review idea of a designated employee, somebody with the experience. While that wasn't adopted, I think supervisory roles have always required that an individual be, as they say, appropriately qualified. Someone who at your firm is knowledgeable not only about your products and offerings, but the new marketing rule. Someone also who has the authority to implement and enforce your policies and procedures. Because for those of you in the audience at firms, we've probably all had a situation where the head of marketing is saying, "But we need to do this," and you need to have somebody who can say, "No, we can't do that," or "Here's a way that we can do that," as opposed to somebody who's in a position just to try to pass things through. Overall, there's no right way, other than to say, and again, I think from the proposal and the adopting standards under the compliance program, that it should be reasonably designed to implement and implemented to prevent violations of the Advisors Act. But practically speaking, how do you decide? So from my perspective, for our firm, we have taken that risk-based approach, and we have really a hybrid model of all three of the options that I was mentioning, the pre, post, and spot check review process. And it's evolved over the years, and it's not a set it and forget it. I think as things change, not only obviously with the new rule, but there will be new guidance. And I think, there's already been a couple hopeful requests that there may be some additional FAQs as we go forward. So those will all be things that even as you move forward with the new process, you'll have to make sure you keep those in mind. But in general, for us, in the process we use, I think for standard materials, things that we've seen lots of times, that we've made sure disclosures and details are accurate and correct, we have a template process. It includes materials like fact sheets and brochures, things that have been produced over and over and generally aren't customized. And I think we've felt comfortable with those. From a post-review process, we even created a template advisory for the individuals that were getting a template approval, where we let them know what was expected under the template approval process, what they could change without having to come back to us for additional guidance, and what would make this a material change to the information so that we would want to reconsider. And then materials such as RFPs, they're more of a hybrid for us. Again, the standard RFPs that we have, we all have seen these where they're the same questions, and you develop established answers. You have an SME process, and these answers have been vetted through that. Again, I think, and we use a post-review process on those. And the beauty of having that SME process in place is that when you have a new question that comes in one of these standard RFPs, that the whole RFP doesn't need to be reviewed, that one question and that new answer can be reviewed. But as long as then you're sticking with the rest of your already vetted answers, that again, the whole the whole RFP doesn't need to be reviewed. And those are things that we'll post-review. Custom RFPs will always present more of a challenge, and will likely be pre-reviewed. But one of the things that we've incorporated in this, and again, this is where it all becomes hybrid, is we talk to the managers and the RFP writers to understand what the content is. And sometimes it does end up where it can be a post-review, but a lot of them do end up as pre. But we've saved like the full-on pre-review for the more complicated materials and RFPs. And I think, Mike was just talking about some of them from the performance perspective. Model portfolios, hypothetical performance, the new extracted performance or carve-outs, newly marketed strategies. A strategy that maybe has been around at your firm for a while but has been languishing and all of a sudden has great performance, or for some reason there's an interest in that strategy, but we really haven't looked at it in 10 years. That's going to be something that we're going to say, all right, we need to start over. Even though it's a well-established strategy, we need to start over because it's been a while since we've marketed this strategy. And finally, we created a category that we called non-product, non-strategy. These are the materials that there's no explicit or implicit reference to any product or service that we have. They're the things I think we were talking about before: market updates, economic outlooks, educational pieces that aren't tied to the strategy or capability. And I think Mike was talking about it before. I've seen those same white papers where the first 10 pages are great and they're educational, and the last 2 paragraphs talk about what we can do as it relates to the previous 10 pages. Well, you've just gone from a non-product, non-strategy piece to an advertisement because you're now offering your services. And so you have to be careful with those. But if done right, those can all be spot checked really and in a post-review way. So I think those are ways that we've put in place practical kind of approaches to that, because we have a team within compliance that does look at material. We can't look at every piece every day, and so that risk-based approach of what presents the most risk and what makes most sense for us, I think is important. And with that post-review process came a lot of training that we've created materials for whether it was the marketing, the sales, and I'm going to say even the investments group, because from time to time you have portfolio managers who are involved in the creation of a communication or an advertisement because they want to have their 2 cents included. And so we have checklists that they would use for something that we would allow for a post-review that reminds them of the disclosures or basic considerations. Because remember, and this is I think a concept in compliance today that is becoming more universal. They are the first line of defense. sales, marketing, investments, when you're talking about communications or advertisements with them, they're the first line of defense, and they may be the ones that are out there actually engaging in that. So you want to make sure that they understand what they can and can't do. I don't know if either Emily or Mike had any questions there. Before I went on to, I did have a kind of a best practice consideration that I did talk to some colleagues, but.
Yeah, I think we'd like to hear that, John, briefly, because we're
Sure.
running short on time.
Okay, so I will just keep going. I did do my own poll on this in terms of what other firms are doing and what their perspective is on that. And I think, as you would imagine, it's really all over the place. Some firms do all pre-review, some firms do all post-review, and some combination thereof. Again, I don't think there is a right answer. I think a key factor in deciding for your firm is, what's the size of your firm? How much advertising do you actually do? Do you engage with retail versus institutional? Because retail, you're going to want to have a stronger and more detailed process. I think a couple other things to keep in mind when you're thinking about pre, post, or spot check. The staff did identify in the release that your process should have a way to detect and correct promptly violations. And I think that's an important thing to keep in mind as you're thinking about, well, maybe we'll just do spot check, twice a year on materials. Well, if you're only doing spot checks twice a year on materials, you may not be able to correct promptly any mistakes or errors that have been happening. And you've been repeating those errors now for 6 months since the last time you looked. And again, so that's a thing to keep in mind. I think we've talked about this a lot, so I won't get into detail, but audience is a major factor in terms of pre or post. Retail is definitely more of a pre-consideration, where institutional, sophisticated can be more of a post. But even in that situation, again, back to the risky, whether it's model or hypothetical, you'll want to consider pre. I did want to add this as well, because this just came up for us literally in the last week. If you create an automated process, so for your website, if you have information that's automatically populated and refreshed and nobody has to touch it, it's as they say, automagically done. But the problem is those don't always work, because this week we found on our website that two funds, their tickers had been exchanged. And no one could figure out how. Thankfully, though, we have somebody who looks at that on a regular basis just to confirm, is the information getting up there properly? So they couldn't figure out why it happened, but we got it corrected, and we got it corrected quickly. But the idea being, automated doesn't mean don't think about it anymore. Automated just means you have a little bit more comfort that somebody's not tweaking it, but you still should pay attention to it. I don't want to go too far on time on this. Do we want to move on to record keeping?
Yeah, I think we're out of time, unfortunately.
Okay.
I did want to thank everyone for listening to the webinar, Perspectives on Implementing the New SEC Marketing Rule. Of course, thanks to our speakers providing such great insights and knowledge and taking their own time to prep for this webinar and participate. Vigilant is available to answer any questions you may have or see how we can help your compliance program implement the new rule into your advisory business. Thank you.
Thank you.
Thank you.